Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Messges. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good evening. Good evening, my friends, and welcome to Melanie After Dark. We're doing 2-a-days now. That's how we roll here. We're doing 2-a-days. I took a little vacation, and so I guess I got to make up some stuff. Happy Friday. Happy Friday to those of you who were not with me earlier today when we did a recap on the Cardi B trial, and wasn't that fun? Well, it was the perfect Adelson antidote. It was perfect. The Cardi B trial was fantastic. Her testimony was everything. She's everything to me. Now, I didn't even really know who she was before I watched her testimony in this crazy personal injury trial. And we recapped it today for a couple hours. And then this happened. So now we're back because, happy Friday. Everything always happens on Friday. And what I have for you tonight, hot off the press, are the two motions, the two decisions from Judge Doolin that we've been waiting for on the Aidan Kearney cases, because it's Friday. So, of course, it's on Friday. But what we need to do first, while we wait for a couple of minutes to get in, a couple people to get in, smash the like button. It's free. Hit the subscribe button. That's free too. Share the stream out. Helps the algorithm. And, grifters got to keep grifting, right? What we need to do first, though, is we need to go back to the July 7th hearing from Aidan Kearney's case, because this is how long ago these motions were argued. And Tim Bradel and Mark Bederow, I don't think has been on the case since February of 2024, but that's how long they've been waiting for discovery in Aidan Kearney's case. And back on July 7th is when we listened to a hearing on Zoom. There was no video, it was audio only. And we heard them arguing. So what I thought we would do, instead of me telling you the recap, is go back and listen to the hearing again. It's only about 10 minutes long, and that will refresh your recollection about what it is that we are hearing decisions on today from Judge Doolin. So without further ado, I'm going to thank Mike Crawford in advance. I'd rather beg for forgiveness because I didn't have time to ask for permission, but because he streams these hearings without commentary, it's better than me watching my own commentary with you. So give Young Jerks a like and a follow, and they're doing the Lord's work out there, oftentimes streaming things. I think when Mike is out walking dogs, he's streaming stuff, right? So this takes us back to July 7th. If you recall, that was the same day in front of Judge Doolin that Aidan Kearney was arraigned on the two new charges of witness intimidation for intimidating the window at D&E Pizza that was caught on camera. And he was with the glarer who was doing the little dinosaur arms behind him, or whatever you call those arms. And the first thing that happened during the Zoom hearing was an arraignment in which Aidan pleaded not guilty to both charges. And then Cosgrove, the real Robert Cosgrove, not the fake one that calls into Will the Glare's show, argues against Bradel and Bederow, who is on Zoom, about why they should not have to turn these things over. So let's take a listen to refresh your recollection, and I may stop and explain as we go along. This again is July 7th, 2025, in front of Judge Doolin in Norfolk Superior Court, because where else would we be?
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay.
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
Okay. Yeah, those are both ordered. So we saw the Commonwealth's ordered to preserve notes of investigators and to preserve video.
And we've learned that lesson before, because remember, during the Karen Reed double persecution, the Commonwealth actually had the nerve, the cojones, to argue that, oh, well, they didn't specifically ask us to preserve Sallyport video, so we didn't specifically preserve the Sallyport video. Everyone learned their lesson in Norfolk County to now specifically ask for every single thing that they want preserved.
What else can I do for you?
For me, or?
Why don't I start with you, Mr. Cosgrove? Go right ahead.
All right.
Surprise!
So Your Honor answered a discovery order the last time we were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradel today. And I had planned.
Yeah, and it turned out 4,000 of those pages were blank. Remember? Are you remembering now? Are you picking up what we're laying down? Grace-Based says, can we replace Cosgrove with fake Cosgrove? Motion granted. Motion granted. Yeah, 4,000 of those pages were blank.
Your Honor, to file that with a motion for a protective order, which I had served on Mr. Bradel a couple of days from the one I gave you.
Thank you.
And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicates of discovery turned over in the Karen Reed case.
And here's what they do. Here's what they do. They say, okay, we'll give you the discovery, but what we want you to do, what happened was we want you to sign this protective order. We'll give you the discovery that, you know, we know owe you under the laws of the state of Massachusetts. We'll give you that discovery, but we want you to sign this protective order saying you're not going to share it with anyone or use it anywhere or cite it in a motion without redacting it. But that's like the condition that we'll give it to you under. And so they're forced to sign these protective orders. And then we're going to hear Tim Bradel argue, listen, this protective order is bogus because embarrassment of a public official is not a good enough reason to keep things impounded or sealed.
Pretty much follow their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradel wishes to bring that practice to an end as of today.
Right.
So,
he wanted to go to Unimpound Town. I'm giving Nurse Kim full credit for that term because I think she's the one who coined that phrase. Unimpound Town. That's where Bradel wanted to go. We got a decision on that today. No spoilers, please.
I'm in a somewhat different position.
All right. Let me hear from Mr. Bradel. Mr. Bradel.
Thank you, Your Honor.
Give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moot. It's gone. Okay. And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it, but I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's
Praise be. Praise be. This is from July 7th. We're recapping a little tiny bit before we read the orders and the decisions. Okay. Okay. So if you're just tuning in, it's not, what do you call that? Deja vu. It's not deja vu all over again. This is the July 7th hearing. We're just recapping before we read the decisions because this is when they argued the motions.
That's really all the Commonwealth has left on the existing stuff is that, you know, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad.
Mello.
This might, you know, cause election shifts, you know, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, you know, from the Commonwealth, and when they say, just, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point, we have to get off of that train, Your Honor, you know. This is a case of immense public interest. This is a case of, you know, First Amendment issues, and I know we may disagree on that, but, you know, that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with you, so that's okay. And, you know, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in? And, you know, these text messages about, you know, and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things.
Sunlight.
So we're not asking to, you know, publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other. And the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Right.
Your Honor.
Glare raid. Hey, Glare.
Handed,
Glarer. What should we call the glarer? Glarer stands. What should we call you guys? Glarerites? What do we call you? Do you guys have a name? Well, thanks for coming over. I think I don't know if there was a hearing after this, but this is when they argued this motion. This is July 7th.
20 minutes ago, a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a written response.
I'd give you that. Was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bederow, you absolutely have every opportunity.
Thank you very much,
Okay.
Your Honor. And
Now, Your Honor, with respect to the items that I was going to turn over today.
So I'll allow the motion. Mr. Bradel, I'm up here.
sorry, Your Honor.
I'm up
It's all
here.
right.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Bederow. My point is this. If you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
All right.
We have to take the candy. It's hilarious. I want candy. That song? Who sang that? I want candy. Okay.
Please note our objection, but thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice. And I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very
Does
much.
that make sense? Okay.
3 weeks.
And
It's
then-
now, that was July 7th. It's now September 5th. It was a little more than 3 weeks.
Judge, just to shift gears a little bit, there's some outstanding discovery that we've
Yeah.
been talking about.
Yeah?
And I want to start off, I know that the court's time can be much better spent in discovery disputes. So we talked about
How? Maybe.
the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out,
Yeah,
you know, I think we're gonna agree to go in person with our people and figure it out. So
yeah, sure.
that's the first thing I want to say. But then, in addition, Your Honor, there's the, this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our third motion to compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And, you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time, but, you know, the rules are the rules, and we need this stuff,
Mello.
and it's gone on way too long. So these are the 10 things that I think are very important, and maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those,
Can you give me an extra week, or?
an extra week?
Thank you.
All right. But it is, Mr. Bederow makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can.
Oh, there's a
bring
video
timely,
version of this
trial to
hearing?
the case.
I don't
Oh,
disagree
man.
with Your Honor. Notwithstanding that Mr. Bredel has some
almost
complaints, and some of them may well be legitimate, there has been a substantial amount of discovery
Yeah.
turned over in this case.
Yeah. If you turn over 5,000 pages today, it's a lot of discovery.
4,000 are
We
blank.
appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Bederow has a number of items as well, Judge.
Mr. Bederow.
Bederow.
Thank you, Judge. Just going back briefly to some of the issues about impoundment,
Yeah.
there are some items that are currently under impoundment, which we believe ought to be released.
Wait, hold on. I'm going to switch to the video version. Oh, actually, Bederow was there in person. Oh, what? Thanks, Aidan, in advance for allowing me to use it.
Because he is an essential witness in that matter. That issue was decided in September.
Except what had happened was we're back here and I got to boost the volume. So hang on a second.
As the court is no doubt aware, Michael Proctor is terminated from the.
Better, volume better. Okay, here we go. This is when Bederow starts to talk. Mr. Bederow. Oh, and here's Cosgrove. If you guys don't know what he looks like, because we never get to see him because we're always on Zoom. Because the audio, this video was not released until a couple of days later.
A timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bredel has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yeah. If you turn over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Bederow has a number of items as well.
Mr. Bederow.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment. Specifically, messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware,
Michael Proctor and a civilian witness on Impound Town. This is what they want. Who's the civilian witness? I think it's Jennifer McCabe. But listen, this is July 7th.
Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Kearney's interest, and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has the other civilian that we're talking about, who also recently appeared on national news with other members of her family.
That's why I don't think it's Kate Peter. Someone who also appeared on national news with her family. The only two women that appeared with their family on national news was Jen McCabe and Nicole Albert. And I don't think Proctor and Nicole Albert were texting. Process of elimination leads me to Jen McCabe.
Defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded this time.
Okay.
And that's their
Anything
argument.
you want to say to that, Mr. President?
And today we got the decision.
Not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other.
I think that makes sense. I think
I won't ask for another day.
that's, why don't I do this? Why don't you all come up to sidebar? Let me take a look.
And they go to sidebar, and now we know that the judge knows. And look how packed the courtroom is. And on September 24th, which is the next court appearance for Aidan, I would like to see even more people in the courthouse. Because listen, your First Amendment rights are at issue here. The Constitution is dying in Massachusetts. That's where it goes to die. Your witness intimidation statute is overly broad, and it's being selectively prosecuted. And Aidan Kearney happens to be on the receiving end of that, facing over 100 years in prison. So it's pretty crowded. This was July 7th. I would like it if we could get more people to get there. September 24th, that would be great. That'd be great.
The second of the three indictments that relates to Lindsay Gaetani, we moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year.
Nope.
So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly.
Lindsay Gaetani was contacting Ken Mello, the special prosecutor, during the alleged acts with which Aidan Kearney is charged, making himself a witness, which is why they moved to disqualify him. And we have the decision on that as well. This is just a little refresher.
4 or 5 times over the course of that day, instead of the police being called. He was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. President.
Could I inquire if Mr. Mello is...
Yeah, they're like, is Mr. Mello on the Zoom? We need proof of life on Mello Yellow. Last time I think anybody saw him, he had an oxygen tank. And, listen, if he's in bad health, I feel sorry for him. But listen, he's a witness. He needs to be disqualified, or he needs to recuse himself or resign or something. And he's like, is he on the Zoom? And then our favorite court clerk, Margaret, is like, no, I don't see him on the Zoom. Mello is the guy who was originally hired to prosecute Aidan Kearney. Mello is sick or something, so Cosgrove stepped in. Cosgrove is a retired judge from Norfolk County, go figure. And so Mello's been kind of MIA. And it turns out he was not on the Zoom, and so therefore that was the end of that hearing on July 7th of 2025. And today, because it is Friday, we have two decisions from Judge Doolin. The first one that we're going to look at is the motion to disqualify Ken Mello. And here we go. Hot off the press, this is filed today, docket number 99. This is docket number 99 in the Commonwealth versus Aidan Timothy Kearney. Let's get rid of Proctor's glow down photo. Memorandum of decision and order on defendant's motion to disqualify Special Assistant District Attorney Kenneth Mello. The defendant, Aidan Timothy Kearney, has been indicted on one count of witness intimidation and one count of unlawful wiretapping. And the reason that it seems like less charges is because this index number is for the Lindsay Gattani case. Presently before the court is Kearney's motion to disqualify Special Assistant District Attorney Ken Mello from prosecuting this indictment. For the following reasons, Kearney's motion is allowed. Yay! Winna, winna, chicken dinner. Background. On February 4th, 2024, Kearney was indicted on one count of witness intimidation and one count of unlawful wiretapping. After receiving discovery material that is currently subject to a protective order, Kearney learned that ADA Mello received telephone calls from a witness before, during, and after Kearney allegedly committed the crimes underlying his indictments. And how did he learn that? Well, he learned that because Tully gave Aidan and his attorneys an entire cell phone extraction of Lindsay Gattani for I don't know, it went back something like maybe 15 years, 10 years. I don't know. I'm summarizing. I don't know the exact amount of time, but hell a lot longer than they were supposed to. And that's how they found out that during these events on, I think it was a Christmas Eve, maybe, Lindsay Gattani had contacted not only Ken Mello that day, but also Tully and Kate Peter. They had a foursome going on, like a text thread of maybe 4 people, allegedly. Discussion. Kearney contends ADA Mello must be disqualified as counsel for the Commonwealth because ADA Mello, in communicating with the witness during the time frame the crimes were allegedly committed, made himself a necessary witness. At trial, a prosecutor, quote, shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness, end quote, citing Commonwealth v. Scanlon. A witness is necessary, quote, where the proposed testimony is material and relevant and is also not cumulative and is unobtainable elsewhere, end quote. In considering whether to disqualify counsel, a judge must closely scrutinize the facts before him or her to determine whether a lawyer's continued participation as counsel taints the legal system. Here, ADA Mello, in receiving communications from a witness while the alleged crimes were being committed, made himself a potential witness in Kearney's case. As such, ADA Mello may very well be called as a witness at trial by Kearney or the Commonwealth to testify to the content of those communications. And I would say you can count on it. Therefore, because ADA Mello could be called as a witness at trial, he must be disqualified from prosecuting this particular case. Order. For the foregoing reasons, Kearney's motion is allowed. It's a win. It's a win. There's one win. XOXO, Michael P. Doolin, Justice of the Supreme Court, dated today, 9/5/25. And what's interesting here is it says August, but that's scratched off, because I guess Judge Doolin didn't get a chance to sign it in August. Anyway, until the 5th of September. Mello is coming home. Mello is coming home, says none of your business. So that's one win. Moving on to the second order of the day, docket number 100. This is docket number 100. Thank you. Please, thank you. Thank you, kindergarten cop. Keep the drama outside. I don't care who you are or what it's about. I don't do the drama here. There's plenty of other places to do the drama. This ain't one of them. You know why? Because I just have no more F's to give and I just don't care. Commonwealth versus Aidan Timothy Kearney, memorandum of decision and order on defendant's motion to release documents from impoundment. The defendant, Aidan Timothy Kearney, has been indicted on several counts of witness intimidation and unlawful picketing to influence a witness, as well as a single count of unlawful wiretapping. And these are the charges for the alleged victims, McCabe's, Alberts, Julie Nagel, et al. Presently before the court is Kearney's motion to vacate several protective orders. Footnote 1. Although Kearney's motion is titled as one requesting documents be released from impoundment, the documents at issue are subject to protective orders, not impoundment. Presently before the court is Kearney's motion to vacate several protective orders that prohibit the dissemination of discovery material provided to him by the Commonwealth. For the following reasons, Kearney's motion is denied. It's denied. Can't say that I agree with this ruling, but I can try and explain it to you in the way that the court has reasoned it to go. Discussion. Kearney requests that this court allow certain unspecified text messages and emails from police officers, district attorneys, and, quote, connected civilians, end quote, be available for public viewing. Be available for public viewing. Period. In support, Kearney raises two arguments. First, he asserts that he and his lawyers have a First Amendment interest in disseminating information procured through discovery. Docket number 89, paragraph 10. Second, Kearney contends the protective orders must be vacated because the Commonwealth has not demonstrated that an actual threat exists as to the witness or victim if the information is disseminated. The court disagrees. Roman 1, First Amendment challenge. The public has a First Amendment right of access to criminal trials and related criminal proceedings. See Globe Newspaper Company versus Superior Court, cited for the premise that the press and general public have a constitutional right of access to criminal trials. Note the difference here between criminal trials and discovery. And in another case, Press Enterprise Company, First Amendment right of public access to criminal trials extends to voir dire proceedings. This right of access generally extends to judicial documents filed in connection with pretrial proceedings, citing Globe Newspaper Company. There is a First Amendment right of access to records submitted in connection with criminal proceedings. Such a right of access does not, however, extend to materials obtained during discovery. See Seattle Times Company, holding that pretrial interrogatories and depositions were not open to the public at common law. U.S. v. Anderson, documents collected during discovery are not, quote, judicial records, end quote. This is because discovery, whether civil or criminal, is essentially a private process because the litigants and the courts assume that the sole purpose of discovery is to assist trial preparation. Exactly. It will all come out eventually, Kai Mai says, and it will. And I will tell you how, and I will tell you why. Bederow said, patience. Here, the large number of text and email messages from police, district attorneys, and connected civilians were obtained through discovery and therefore are not judicial documents that the public has a constitutional right to access. See Baxter v. Abbott Labs, noting that secrecy is fine at the discovery stage before the material enters the judicial record. And Bank of America, stating that discovery, which is ordinarily conducted in private, stands on a different footing than does a motion filed by a party seeking action by the court. Consequently, contrary to Kearney's assertion, quote, an order prohibiting dissemination of discovered information before trial is not the kind of classic prior restraint that requires exacting First Amendment scrutiny. Seattle Times Company, which is a U.S. Supreme Court case, or United States v. Lind, which is a Virginia case from 2002. Roman 2, protective order challenge. Pursuant to Massachusetts Rule 14, the judge may, upon a sufficient showing, issue a protective order that provides the discovery or inspection be denied, restricted, or deferred, or make such other order as appropriate. The decision to enter such an order lies within a trial judge's discretion. We learned a lot about the wide latitude of judge's discretion during the Karen Reed trials because Judge Kearney would often remind us of her wide judicial discretion, and she would often wield that power as widely as possible. Quote, protective orders serve to shield litigants and third parties from unwarranted disclosures and as a practical matter to facilitate the discovery necessary for a trial. In issuing protective orders, the privacy interests of third parties have justified restrictions on the dissemination of discovery materials. See US v. Bulger, coincidentally, 2012. The privacy interests of third parties weigh in the mix of interests to consider. See also Seattle Times Company. There is an opportunity, therefore, for litigants to obtain incidentally or purposefully information that not only is irrelevant, but if publicly released, could be damaging to reputation and privacy. The government clearly has a substantial interest in preventing this sort of abuse of its processes. That is a direct quote from Seattle Times Company. Kearney argues that the protective orders must be vacated because the Commonwealth has not demonstrated that any actual threat exists as to the witness or victim, Lindsay Gattani, if such, or witness or victim, the witness or victim in these cases are the McCabe's and the Alberts and Julie Nagel, because I think the ones against Proctor and Buchanan were dismissed, right? If such information is disseminated. Footnote 2. Commonwealth v. Francis, on which Kearney relies, is inopposite because it pertains to the Commonwealth's burden when moving to restrict a defendant's right to cross-examine a witness, not the Commonwealth's burden when moving for a protective order. However, a threat of physical safety is not required for the issuance of protective orders. Footnote 3. In Commonwealth v. Cheers, the court determined a sufficient showing for a protective order may be made without any intimidation or misconduct toward any witness having been shown, provided there's a showing that one or more witnesses fear retaliation or intimidation, and that there's a rational basis for their fear, whether based on the crime alleged, their knowledge of the defendant, or their knowledge that witnesses have suffered retaliation or intimidation in comparable cases in or around the community. In making such a determination, the court reasoned that if a sufficient showing required some evidence of intimidation or other misconduct towards a witness, then the safeguard of a protective order under Rule 14 would become more theoretical than real. It is enough if the Commonwealth can show privacy interests justify the restriction on dissemination. Here, the Commonwealth has shown that Kearney has, in the past, improperly posted content online discussing very private material provided to him through discovery. Specifically, after Kearney was provided an unredacted version of a witness's cell phone, he agreed to a protective order that prohibited him from disseminating any information obtained from the witness's cell phone that is unrelated to his defense. Despite this agreed upon protective order, Kearney continued to share this witness's private information that was not pertinent to his defense. After the court issued a second protective order, barring Kearney from posting or otherwise disseminating any material from the witness's cell phone directly or by means of any third party, Kearney continued to discuss contents of this witness's cell phone that is wholly unrelated to his defense. I think they're talking about Lindsay Gattani's phone dump here. Kearney argues that because some of the discovery material pertains to public officials, any misconduct they may have committed should not be shielded from the public. And I agree. While there most certainly is public interest in how public officials behave, this does not mean that discovery material, which has no tradition of being publicly accessible, should be disseminated at the potential expense of the public official's reputation or to influence potential jurors. Footnote 4. Kearney has in the past stated his desire to influence the jury in Commonwealth v. Reed. See docket number 86. So they're using everything he's ever said against him. And what, what else would you expect? Can somebody make a public records request to get the text messages of Proctor and Mello and Tully as public officials? Maybe that's the way around it. Get your pens out, folks. Get your pens out, because you know it exists and you know where it's located. So get out there and request away. Corey Hopkins, request away. It is a lamentable fact of life that parties in newsworthy trials may attempt to use the media precisely for the purpose of influencing public opinion by disclosing discovery materials. Moreover, Kearney's request also concerns text and email communications pertaining to, quote, connected civilians. The dissemination of these materials could result in these individuals suffering, quote, clearly predictable injuries to their reputations that were likely to be irreparable, end quote, citing U.S. v. Smith. I'm quoting U.S. v. Smith, the earlier version. Or it could be a totally different case, I'm not sure. Accordingly, restrictions on the dissemination of discovery materials were and remain necessary to prevent unfairly prejudicial pretrial publicity, which might hamper the selection of an impartial jury, and to protect the privacy interests of third parties. For the foregoing reasons, Kearney's motion is denied. XOXO, Michael P. Doolin, Justice of the Superior Court, dated 9/5/25. Yes, that just spoke volumes, didn't it? Because the judge knows what's in those messages. Judge has read them. And so therefore, he is telling us without telling us, if we read between the lines, how damaging some of these text messages and email communications between the connected civilians and the elected officials and law enforcement could be. So when Aidan says these things will blow your mind as being a million times worse than what we saw in Proctor's text messages during the Karen Reed trial, I think, in my opinion, Judge Doolin just confirmed that. What do you think? And so his ruling is basically saying that under the case law that they've cited, many of which are U.S. Supreme Court cases, not a lot of Massachusetts case law in there, I've noticed, mostly federal. Discovery materials are not necessarily required to be shown to the public because they're just discovery materials. They may not be admissible at trial. They may not be relevant. But if and when there is a trial in this case and these things come into evidence, they will become public. And the fact that they're still under a protective order means that if Bederow is furiously typing away at that mega motion, that some of the stuff may have to be redacted. And that's the way it is for now. But yeah, if they're admissible during trial, they will come out during trial 100%. Because they're going to be germane to Aidan's defense. I don't know for sure what these text messages say, but if they're between Jennifer McCabe and Michael Proctor, I can bet it's things like, why haven't you arrested him? When are you going to arrest him? Kearney needs to go to jail. Trying to influence the persecution of Aidan Kearney. And if it's between people like Mello and Tully, because he talks a lot about embarrassment to public officials and influencing elections and things such as like that. And he just disqualified Mello, Judge Doolin did. So I'm thinking some of this stuff is also going to embarrass and implicate maybe Mello and Tully. And the not so confidential informant, Kay Peter and Lindsay Gattani and Jennifer McCabe and Michael Proctor. And they're probably, in my opinion, really, really hella damaging. Hella damaging. And that's what I think. This is not a blanket ruling across all discovery, but that's a great question, Lola, the good dog. This is just specifically the protective order pertaining to the stuff that Cosgrove turned over that Bradel and Bederow agreed to sign a protective order to get. Okay. Morrissey too. Yes, Morrissey and Proctor. Agreed. Glamasuz, agreed. Stephanie, thanks for your 10. If the embarrassing messages lean towards being more probative than punitive in the motives behind the charges, wouldn't they then be admissible like Proctor's texts and Karen Reed? Well, I think because a lot of these, all of the charges include witness intimidation, right? So if these text messages prove that these people were not intimidated by Aidan Kearney, they just wanted him locked up, or that they colluded behind the scenes to have him charged, they're coming in. They're absolutely coming in. And I do think, I don't exactly know what's in them, but I do think that they absolutely will be more probative than prejudicial, and that they will be admitted in order to ensure a fair trial for the defendant, right? Great question. And thank you for your super chat, Stephanie. No Love of the Traveling Trooper said Cardi's trial coverage was so fun. I just saw it. It was so fun. We had a great time today. Check it out later if you weren't here. Hey, it's me, just because. Thanks for your 20, just because. I appreciate you. Captain Corruption Expose. Thanks for hanging out with 20 months. What's the deal with Karen's phones? I don't know. I saw somebody sent me something that Cosgrove said that he wanted to hang on to it because they're trying to charge her with some more things, but I don't have the receipts on that. So I'm not quite sure. Somebody sends me the receipts. I'll look at it. Thank you, Jessica Lynn, for becoming a member. I think you're going to like it here. How dare you? Says, so happy to spend part of my 69th birthday with you, Mel Mods, and happy 69th. Happy 69th birthday. Everyone say happy birthday. How dare you? From Canada. Thank you so much for your super chat. And we're hoping you have an amazing birthday. Stephanie said, can it be entered into the judicial record through the mega motion or other proceedings that are coming? Well, no. Anything that is still under protective order will have to be redacted from the mega motion. And not until the protective order is lifted would those things be available to the public. Now, another question would be, can the media make a motion to try and get a hold of this stuff, saying, we, freedom of the press, we have the right to know, we have the right to report on it? Would that be successful in this case? It might not be, because it's pretrial discovery again. But will the media step up? Will the local media step up and make that motion? Do they care enough? They should care enough, because Aidan Kearney's case directly affects them. They too are journalists. And Massachusetts is one of only a handful of states that does not recognize any sort of journalistic privilege or shield. And so you would think that the other journalists in Massachusetts would be scrambling to get into court to protect themselves. And they would really care about what's happening to Aidan Kearney, because they could be next. Right? Thank you, Stephanie, for another great question. No Love of the Traveling Trooper says, so the Commonwealth can ruin Turtleboy's life by hiding the evidence. And the answer is, they're hiding it for now because it's not admissible yet. And so it's not part of the record. Hold on a second. But that doesn't mean they're going to be able to hide it forever. Both sides entered into a protective order voluntarily, and the judge is keeping it in place for now. And that is where we stand for now. That's a great question. Coco, do you see any media interest outside of a few YouTube channels? You tell me. Do you guys see any interest in the media? Is Core TV covering this? Vinnie Politan covering this? You know, Billy Bush covers it now and then. All right. But, you know, is Ted Daniel reporting on this? No, not really. Hang on a sec. I have a special guest for you, so hold on tight. They should be taking an interest in it, because they should want to protect their own behinds, right? You'd think. Lisa from Massachusetts says, remember, any person can submit a FOIA request. Perhaps we should go through how to FOIA. Love you, Mel. Yeah, Corey Hopkins is going to come on one day, teach you guys how to do it, how to write the letter, what to do. It's different in every state, but she's fully familiar with how to do it in Massachusetts and other states. So as soon as we have a spare moment, we'll try and get that together. But yeah, great point. Thanks, Lisa. You don't need to live in Massachusetts to submit a public records request in Massachusetts. I saw that question fly by as well. Ashley says they're in such a lose-lose situation because if it is dropped for government misconduct, he will sue them. Yeah. Yeah. True. That's one of the reasons. But it's discovery material, and that may not necessarily be. The attorneys get to look at it. The client gets to look at it. Aidan gets to look at it. They all get to look at it. But the public right now does not have a right to know, according to Judge Doolin. And that is it. That's what he says. For now. For now. For now. And I have a special guest for you. Here he is. The one, the only, Mr. Bederow. And I have a special guest for you. Here he is. The one, the only. I'm echoing. I'm echoing.
Is that me?
Here he is. The one, the only. I'm coming through your speakers, I think. Is there a way for you to, do you have headphones? Wait.
Please sign off. I'll try again.
Yeah, maybe because you don't have headphones on. I tried. He's coming. He's coming back. I don't know how much he can say to us. I don't know how much he's allowed to say, but we'll take it. Whatever he has to say, we'll take it. But there's certain things he can't answer, attorney-client privilege and all. And it's his case, so he can't really talk about it, which is another reason why Aidan can't really talk about it. So we'll have to wait for Mr. Bederow. He's never had to wear them before. Yeah, I don't know why it was echoing. I thought it was coming because it was coming through his external speakers, and then my voice was coming back in. Why else would it be echoing? We'll let him come back. And also, if nobody saw Howie Carr's article today, Howie Carr's column is really good. It's called, "It's a Crime What Karen Reed's OUI Cost." Mr. Bederow.
How are you?
I'm good. How are you?
Good. Nice to see you.
That's good to see you too. What's up?
Anything newsworthy going on?
Yeah, a couple decisions dropping on Friday from Judge Doolin. So,
Yeah. Interesting.
what do you think? Any legal analysis that you can, I gave mine. What do you got to say? Anything?
Well,
Can you say anything?
kind of have to be careful what I say.
Yeah.
But, the decision with Mello is about a year too late.
Yeah.
In a few weeks, there'll be another motion to toss him off the other case, which I assume will be granted for similar reasons, stronger reasons, frankly, probably. So we expect he'll be subject to full subpoena power, both personally and documentary, which will happen. As far as the impounded stuff, I don't agree with it, but it is what it is. He's the judge. Eventually it all comes out. But I think the disappointing part is that some of the documents and issues that people presumably want to see involve people who have made public statements, who have said many things. They've put themselves out there. We've seen other documents that in the last 3 or 4 weeks, the DA's office disclosed to the public pursuant to a FOIA request, which kind of undermines, I think, their argument that these kinds of things need to be secret.
Yep.
There's a number of things I could say, but I probably shouldn't.
So when people make FOIA requests for these items that we know now exist, that are now impounded, they may actually receive them because I'm assuming, the Marcy email dump that people have received pursuant to FOIA request that they've published and stuff. You guys have those and you're not allowed to publish them, but the people who are obtaining them, the private citizens that are getting them, can.
Yeah,
So,
the order relates to us and a protective order and all those sorts of things, but certainly third parties have FOIA access. Media institutions have a right to attempt to intervene on First Amendment grounds. These are cases of public interest. So certainly, there is an argument to be made there by someone else, not us,
Right.
which have nothing to do with the possible dissemination of information by anyone who's a criminal defendant or involved in a case. The public generally has a presumptive right to know what goes on in public trials and public court proceedings. And this is certainly a matter of public concern. Some of the people involved are public servants who have already been disciplined for their conduct. They're,
Proctor.
you said it, not me, involved in this and other things, have spoken out publicly, as I said. So, someone else will have to make that argument. At the end of the day, we're just lawyers. We present the case. The judge sees everything. The lawyers see everything. It's just for now, the public doesn't, but eventually it all comes out.
So I'm assuming that in this mega motion that you're furiously typing away at whatever protected materials are contained in that motion are going to have to be redacted.
Well, I mean, if there's an order which precludes the dissemination of or public filing even of certain things related to certain situations, and of course that would have to be redacted depending on what it is and what's being said. But that's down the line too. That's the last thing one does in preparing something like this, is worry about what's redacted and what's not. We're more worried about the legal arguments and the factual arguments in support thereof. And
so what's next? So September 24th is the next hearing date. And what is that a hearing? What's it on? What's supposed to happen then?
The can gets kicked down the road, and who the hell knows what is really supposed to happen. I would imagine by then we hopefully will have filed something with respect to certain motions and other applications. But, these are general updates for general things. But
status conferences. I think that the general public doesn't realize how boring it is being a lawyer, because you go to court and you waste so much time sitting in court. I always thought lawyers should be called waiters, because all you do is wait in court all day long for your case to be called. You could read 17 physical newspapers, talk to 20 friends, and waste the whole day in court just waiting.
Yeah, it's also interesting that Massachusetts has no speedy trial statute. So that, as you know, in New York and other states, there's a certain process that has to be filed. There are certain benchmarks that have to be met, certain bases for adjournments, a natural order of what a case is adjourned for, as opposed to just constant general updates. We'll see where we are kind of things. But, again, these things do take time and they'll work themselves out. Progress was made. We have a new name on our witness list for now in one of the cases. You saw the ruling today.
Oh, Mello. Yeah. Well, we knew that you're going to win.
We anticipate that'll be for both cases. That opens up the door to a whole new line of subpoenas based on communications and other things, and things that we're aware of that, pursuant to the court order, we can't really talk about.
Are we anticipating any sort of evidentiary hearing in this case, the way we saw in, for example, like the Brian Walsh case, where Buchanan and Tully or Fanning had to come in front of Judge Frenier and give testimony, like Judge Cannoni should have done in Karen Reed's case?
We will be asking for an evidentiary hearing, which, if the motions that we are seeking are not granted, think are absolutely appropriate. And I would expect that they would be granted, because I think you'll see in few weeks or whatever it is that at a minimum there will be material questions of fact that have to be resolved before the court will be able to certainly deny the motion. There's going to be, unlike what you perhaps didn't see from the prosecution in Karen's case, lawyers file affidavits or affirmations that allege sworn facts that are supported by documents, which create questions of fact and clarify issues, and we expect to do that.
Are these cases going to be consolidated for purposes of trial, or are they going to be two separate trials?
Well, there's three actually, but
right, because of the window. Yeah, the window is the third.
Yeah, I would assume they'd be separate. I don't see any basis to combine them. There's always the judicial economy argument, but I don't think that's the case here in light of I think the prejudice that would attach to combining incidents that have nothing to do with each other. Certainly the 23 and 24 indictments have nothing to do with each other. And also, at least for the time being, we're in a situation where the prosecutor of one of those cases is going to be a defense witness at the other case. So it's hard to fathom how those cases could be combined. But
Okay. Okay. So Mello's only been removed from the Lindsay Gattani matter, not the other two involving the Alberts, the McCabe's. And
yeah, in a couple of weeks, I would expect, again, when we file papers, that there's literally no chance, in light of what we will allege with documentary support, that he will be allowed to stay on. I think it's just a matter of time.
shouldn't he just voluntarily withdraw to save the court the trouble and the time?
I mean, that's for other
That's an
people.
option, right?
I mean, that's I don't want to speak to what he personally wants to do or what the prosecution thinks is appropriate. All we can do is say that it's certainly more than apparent to us that he can't possibly stay on the case under the witness advocate rule. He knows too many things and is too involved and has too many communications that are central to our defense in the other indictment that he has not been removed from. So I don't think, again, that there's any chance that he'll be around for that trial.
Well, he colluded to incarcerate your client, basically. I mean, I can say that from looking at it from the outside. That's what it looks like to me. And that's a big problem ethically.
I mean, we'll say, we'll file the documents and say what we can say in court, and people can read what's not impounded or under a protective order, and look at black lines and not know the rest. We'll see.
If he's technically still the attorney of record on two of the cases, why have we not seen him in however long? Do we have proof of life? Do we even know that he's still among the living?
Yes, he's living, but I mean, I can't speak to, out of respect for him personally and whatever they're doing. I don't want to speak about anything other than to say he's going to be a witness at both cases. There's just no way around that. And, they can take whatever position they want to take, but it's going to happen. He's going to get kicked off.
Yeah. Well, we can't wait. Although the trial on this case, since there's no speedy trial statute, it could be years down the road. You think?
Well, we're hoping that there won't be trials, but we'll see.
Oh, all right. You think you're going to have it dismissed? Because he's definitely not taking a plea. I mean, I can't imagine that he would take a plea. So dismissal would be a good option.
We believe there is a strong basis for dismissal, but again, the judge will ultimately have to determine that. But
so many Easter eggs and such a small basket. I just don't know which ones to pick. Yeah, I should just call you the Easter Bunny. We should call you the Easter Bunny because you got all these Easter eggs that you can't talk about. And I'm dying to know. I want to know. I'm nosy. I just want to know.
No, I understand. But, there are orders that have been issued by the court. It makes it hard. And when you're dealing with something like this, that, is a matter of public concern, and there are people talking about it all the time, and including people saying all kinds of outlandish and crazy and false things on the internet, lawyers and clients, you do have a right to make statements, to push back to people who attempt to prejudice what you're doing. But when you're still under or subject to a court order that restricts certain things you can say, it becomes more difficult.
Yeah. I mean, I like how the judge had to throw in there that, one time Kearney published a phone number, and so therefore he can no longer be trusted with this information. Felt like that was a gratuitous kind of throwing it out there. Part of the decision, in my opinion.
I mean, look, I'm not complaining about the judge. I like the judge.
Yeah. He likes you too.
No,
he likes you. He's quite affable. He is one of the most entertaining judges, I think, in the county.
Well, I mean, look, really, mostly everybody likes me, unless you think that, on these cases that clients are evil and cause cancer. Somehow the lawyers become part of that. But, that's a new experience for me, being personally put in with clients that people hate because, the internet. It's pretty weird.
It's a new experience for all of us. I don't think that any of us thought that when we came on the tubes of you to talk about how John O'Keefe was not hit by a car, that we would be subject to such scorn and
I had
ridicule and hatred and criticism and public personal attacks.
from all quarters, you know,
Yeah.
not even people who knew the people involved in the case, from
No, just
couches.
people
Couch
wiping
all
Cheeto
over
dust off their couch. Yeah.
Yeah, exactly.
So what do you think about the expenses in the Reed trials? Any thoughts on that? Did you have a chance to look into any of that stuff? I went over all the receipts yesterday.
I mean, I saw the list. I mean, I don't know what more evidence people need to get a new DA to spend close to $2 million, spending that amount of money for just comically bad experts, that amount of money for a prosecutor who is essentially a ringer. Again, that's the DA's problem, not its problem. All these other expenses about, mining social media to look at jurors and witnesses' families. And, I got a kick. I think I saw a New York law firm I know who was throwing a few dollars to do a few things. I'll have to.
Oh, Seiden?
Yeah.
Yeah. That sounded familiar to me too. I'm like, yeah, I think I know them.
That's who I think. If that's who I think it is, and I'm pretty sure it is, it's somebody I used to work with in the DA's office 100 years ago.
It could be. So you worked in the prosecutor's office for quite some time in Manhattan. Is it common practice for a prosecutor's office to hire jury consultants, outside jury consultants?
You don't usually see a DA's office do that. You
Right.
certainly see well-funded defendants from time to time will do that. I'm trying to think. I don't know offhand if I've ever heard of, maybe in just like the hugest of huge case, that they would hire a jury consultant, but not. I mean, the expenses as a whole and what they were paying for and the percentage of their budget that they blew out on this is, I mean, it's so irresponsible, given the rest of the cases that they have to prosecute and what the salaries they need to pay people, and they spend all their money on a ringer. I mean, what kind of message are you sending to the people who work in that office? I don't know how anybody with a straight face can say that this is a good place to work, and I'm sure there are fine prosecutors in there, but they see what that place has become. And you just sit there and say, morale in that office must just be a joke.
Let me tell you an interesting story. Somebody that I know who would like to remain anonymous was recently on vacation on Block Island, like for real, on Block Island. Block Island, right? It's off the coast of Rhode Island and Montauk, right? And ran into none other than Laura McLaughlin on the ferry to Block Island. And while this person was in Block Island, had some conversations with Laura McLaughlin that were very revealing. In fact, was told that she and Lally were instructed not to speak to Brennan unless he spoke to them first. I mean, that is like something out of like a Blake Lively. Now I'm probably going to get blocked for even just saying her name. Are you surprised? Does that surprise you?
That prosecutors I'm assuming between the two of them have, I don't know, 30 to 35 years experience.
Mm-hmm.
Apparently were worthy enough to, by themselves, try the first Karen Reed case. If you believe in this kind of stuff, they tried it better. If you believe in the results that they got, better than, he who should not be named, apparently they're not allowed to talk to. But the idea that they would be instructed as experienced prosecutors, whatever you think of them, and I mean, I don't think much of them, but that's neither here nor there, that they would be instructed not to speak to Brennan unless spoken to as if they are 4-year-old children.
Mm-hmm.
It raises a lot of questions. Number one, who the hell's idea was that? Number two, if you're Brennan, how do you even allow that? How do you not stand up for these people who are going to be your colleagues and say, we're going to be a team? And you know, and these are the reasons why also they were always destined to lose. They were always outgunned. They were always overmatched. You know, you saw a great team on Karen's side who worked together, split up the labor, were together all the time, worked well, versus now a level of dysfunction, which is just disgraceful. But I don't even know what to make of that. But, you know, they also really should be careful about what they say. Maybe that's why Lally was the famous, you know, non-responsive and non-emotive person on the first day of jury selection, when he wouldn't even identify himself and didn't even respond when he was introduced because, you know, he didn't have Brennan's permission. I don't know. If that's insane, I can't believe we haven't heard that before. And that's the kind of thing that is another example of just a level of dysfunction in that office that's just disgraceful. And the other part of me says, I mean, if I'm Lally or McLaughlin, whatever you think of them, again, all kidding aside, if they're willing to play by those rules, then you know, I question their own self-dignity. Because I mean, if that were me or that were you and you were brought in that situation, the idea that you would be, you know, look at the floor and don't talk unless spoken.
Because he probably billed for every hello.
You know, I mean, if they had any self-dignity, they would have said, get the hell out of here. I'm not, and, you know, piss off. That's just not how we're going to do it. That's amazing to me. I can't believe that.
Could you imagine? The Aperture billing records, these guys were billing 24 hours a day on some days. They had, it's like they had no other clients. It was the golden goose that kept on giving.
No, I mean, look, there's a lot of scandalous questions about their billing practices, their competence, clearly, their ethics and their representations and what they did, both academic and beyond. There are fair questions about how they got hired in the first place. You know, we know from the FOIA request that came out that, you know, the connection was a former state trooper who owns or is part of the ownership group or something of that company. And that's who they agreed.
Yeah, he was MSP, that Andy Clean guy, right?
And then they end up, you know, basically doing nothing, literally nothing that the state police didn't do, other than, you know, they have cleaner. Well, Welcher had a cleaner resume. The other guy had a worse resume than Trooper Paul. But I mean, they did no original work. They did nothing. And, you know, to the tune of $600,000, as you said, billing essentially 24 hours a day. I mean, the taxpayers in Massachusetts, you got fleeced. And then when you thought you had it figured out, when you were told it's going to cost $75,000 or whatever it was, and we're going to do this ethically and properly, you got fleeced again and again and again. And you're going to get fleeced again when they all, you know, or at least some of them, the cops, get sued, because if there's a judgment that comes from that, if that eventually happens, that's coming out of your pocket too, as the taxpayers.
Yeah. And I love how the billing records were so detailed that they indicated that they reviewed Trooper Paul's everything, all of his testimony, all of his reports, all of his everything. And I remember during the trial when I think was Bob Alessi, who was crossing Welcher, wanted to ask about Trooper Paul's results and reports, and he was not allowed to inquire about it because they claimed they didn't review any of it or use it in their analysis.
You know, the billing records, they're interesting. I mean, look, we've both billed hours and you know, in tenths of hours. You know, the meter runs at 0.6
every 6 minutes.
Yeah, exactly. You know, when you have that 5-minute phone call, you know, stay on the phone one more minute so we can, you know, clink it up to the next one. One of the things that jumped out at me about the billing records were Brendan's records. By the time they were, if I saw it correctly, I only perused it, been busy. But when you looked at what I think are his records for the last several weeks while they were on trial, it was a straight 12 hours a day, every day, 12 on the dot for, you know, day after day after day, which sounds more like, I'll just bill, you know, from 9 to 9, as opposed to I'm on the taxpayer dime and I'm billing, actually calculating time. I mean, it's statistically, it's virtually impossible, even if you're on trial, that you would have the same exact 12 hours billing for weeks and weeks or whatever it was at a time. So,
But they
you know,
kept paying. They kept paying.
stamp it and pay it. Yeah. I mean, what are they going to do? The whole thing is just so disgraceful. And when you learn that it was the percentage of their budget that it ate up, and with all these other cases, and it's like every big murder case in Massachusetts, for whatever reason, seems to be in that county. I don't know why. They don't have the resources to deal with other stuff. They have a statewide crisis where all these defendants had to be released because they couldn't even get money to get these people public defenders. And you just see there's a lack of resources and all this and that. And, Brennan, his staff, the Aperture people, all these other groups and experts, I mean, they're just eating at the trough. I mean, it was pathetic. And to put forth the case that they put forth, man, they were much better off when they didn't have to pay a prosecutor. They didn't have to pay experts because they had the state police. And somehow, some way, I guess Lally picked a better jury because they at least got a few jurors, or 9 of them even, just to say, I don't know, maybe. And it's a real scandal.
How pissed do you think that Brennan is that Aperture got paid more money than he did? Love to be a fly on the wall when he found that out.
It's amazing, right? An expert who testified 1 day or 2 days. The other guy with his, caused real damage to the case with his fake credentials. They were so bad they couldn't even bring them back for rebuttal like they said they were going to do. You saw what Brennan did, and you figured just Brennan and these, bizarre experts were what, 1.3 million dollars. What a joke. I mean, for that level of performance, they delivered nothing. I mean, the return on investment, and you can't judge it by win or lose. I mean, prosecutors lose trials from time to time, but I mean, this thing was never about justice. In my view, I don't think it was. It was about, you're going to do it, so I'm going to hire you. And you see now, when you look at some of the other Morrissey emails that were released in the FOIA request, see his involvement, and you see the way he behaves, you can get an understanding what he's doing. I mean, when he came across, what's her name? Waffles and Pizza Hyde.
Jessica.
Right. When, well, we may have this expert who's gonna, I think you may have an issue here that looks good on the Google search. Hire her, just that's their criteria, right? Just who's going to say what I need them to say. And the more you learn about the Aperture people and the connection with the state police veteran who retired and who's connected to Morrissey, and Morrissey apparently used him in his own situation when he had a car accident or something, the whole thing just stinks to high hell. It really does.
Lynn Beeland was in charge of approving the bills, for the first trial and paying the invoices. And then, she ran out of there, leaving skid marks when Traub and her left around the same time. And then Lisa Beatty, who is an ADA, who I think is trying one of the cases I'm following. I don't know if it's Walsh or one of the other cases. She was then in charge for trial number 2. And she was rubber stamping Aperture to the tune of $45,000, $55,000, $75,000 a month, with no questions asked. And then this guy, Nicholas Bradford, comes from Pittsburgh to testify on behalf of Bodie Labs. And she's questioning his toll bill for a toll for a bridge that he went over.
What does that tell you? I mean, if Aperture's, most favored nation status because of the relationship versus we need to, nickel and dime and cut cost everywhere else. So I need to see your Easy Pass. It's
Turk. That's what it was, Turk.
The place is a train wreck. I mean, everything about and inside that office is just a train wreck. And then, you're dropping bombs today saying that they're not even allowed to talk to Brennan.
No. It's like being on set with a really famous actor and don't look at him and don't talk to him and where are my green M&Ms and
wow. I can't believe that. And the fact, that she's telling people that privately, but it hasn't come out publicly. But of course, you just put it out. Public.
Well, it's, it's confidential and, according to a source that, may or may not be true, and let's not go after her about it. But apparently she's very nice and was very, friendly and, happy that someone wanted to talk to her about the case. So,
well, I mean, I guess that's fine. I mean, what people should ask her is why she said a year and a half or 2 years, whatever it was, when she said there's, I'm paraphrasing, obviously, but there's nothing exculpatory in here when, in fact, 99% of what they got from the government appears exculpatory. And, you look at the defense in the second trial, and why did Karen get acquitted, right?
Mhm.
Clearly the engineers, the, non-exculpatory evidence from the government, clearly the Proctor evidence played a part from the government. You could go on and on. Some of those Higgins messages probably were from the government.
Mhm.
None of this is exculpatory, and you just wonder who says that. Were you told to do that? Did you read anything? Is this, were you told that day that you're not going to be allowed to talk to anyone unless you say this? Who knows?
I don't know anymore. The whole thing makes my head spin. I don't know what's going on up there, but it's like really being in the land of the lost, which is why we sometimes put Chaka up in the corner just to remind us where we are. It's Chaka.
God, it's crazy.
Final thoughts, anything? I'm exhausted. How tired are you?
Tired. But I was on vacation, so you budget time, and I knew coming back the first couple of weeks or so were going to be kind of heavy on this. So I'm a morning person, so I'm fully capable. I'll get up at, like, if I have to, 4:30 and put on the coffee and just go. The difference for me is I want to be done by like 2 p.m. in a perfect world. I'm just one of those.
Right.
I'm working tonight, although I think at this point I'm checking out for tonight. But
you could bill for this.
Yeah. Well, no.
Bill for half an hour. No.
Maybe watching. So 12 hours. This is 12. Yeah, I'll just bill 12 hours a day
every day.
Right.
Because
just 12 hours. Today's 12.
I mean, anybody out there who's looking for a job to try and get a contract with the DA's office for Norfolk County as an expert witness. I mean, I've never heard of a DA's office hiring not only jury consultants, but then a PI firm to dig up dirt on the defense experts. Is that something that is done in DA's offices?
Hiring other people to do it, no. And it makes you wonder that they wanted to do it and leave no fingerprints and just hand it to Brennan if they found anything, and not be in a situation where, the goons from the state police had their fingers in the pie. But again, there's nothing wrong philosophically with investigating the other party's witnesses to see, if there's something big. I mean, you saw it with Burgess. That was big, right? That was
right. But that wasn't found by the PIs that they hired to do that.
Right. But I'm just saying, in principle, looking at your opposition's experts is normal. But for them to pay taxpayer money to hire and outsource investigators to dig through the mud looking at these people, again, if I'm a taxpayer and citizen, I'm thinking, like, what the hell is wrong with you, man? What are you doing? Why are you doing this? Why can't, if you're going to do this, why can't you have some paralegal, state trooper, or somebody use a thing called Google? Start there.
Mm-hmm.
And wherever it leads, you have the ability to look into these things. But the idea of signing contracts and the term of engagement is you're going to dig for mud so that, maybe Brennan will be able to destroy some witness or whatever, or convince them not to testify, but you also have to understand who's the prosecutor in this case. Prosecutor is, and I don't mean this term in a completely negative way, but like, facts are facts. He's a mob lawyer, essentially.
Yeah.
And that's how they do things. This is not a traditional prosecutor who is doing this. It's somebody who they brought in who they gave, made all the right statements initially. Clearly, that was all bullshit about, my primary job is to make sure, and I'm going to do this fair. You knew that was not true. He revealed himself by looking at his petulant statement when there was an acquittal that this is wrong. And this is all because of, witness intimidation. And I believe she's guilty. There was never a good faith. They weren't bringing him in to reevaluate, which is the way they sold it. They were bringing him in to do what Morrissey wanted. And again, you look at the emails that he sends, hire this person, go use it, he wants people who in advance are going to do what he wants. And,
don't talk to him.
The idea that he was not involved in any kind of decision making in that case is hard to believe. And again, you saw it in public released emails, even as it relates to our case, where he was ostensibly recused, but half his emails, most of which are private, burner accounts, by the way, but are complaining about a certain client, urging court officials or authorities, whether it be the attorney general or someone else, to do something. So, recusal doesn't really mean recusal, apparently. So that's none of this is surprising because that's who they are.
Reminds me of a song. I'm a fool to do your dirty work. But, it's like and you can see how dirty it was by looking at all of the invoices that they paid for that trial, because the first trial was completely different from the second trial. And when you're out there hiring PI firms to dig up dirt, including foreclosures and financial difficulties of an expert witness who wound up not testifying, by the way, I think his name was, they use all initials in their invoicing too. Like you could tell that they were trying to hide things, and then there was, analysts looked up this. They didn't even put a name. And then they were like investigating and then digging through social media accounts of all of the jurors, the entire 150 person panel. Hiring outside $20,000, paying a firm $20,000 to do that. May not be illegal, but is it though? Because if the jury list is supposed to be sealed and confidential and only available to the attorneys, are they allowed to give it to these outside jury consulting firms to go do their digging?
It's a tricky question. I don't know, only because it's not the kind of thing you usually see. But I mean, even if you wanted to look into potential jurors, most normal people would have either a paralegal or an analyst in the DA's office Google the jurors and see what's on their social media or not. And obviously, if something comes up and, this juror is in the free Karen Reed page, all right, they shouldn't be a juror. I mean, that wouldn't offend a normal person at all. That person shouldn't be a juror, or vice versa. They're in the anti-department or whatever you call it. But the idea, again, that you're spending taxpayer money to hire goons to dig deep into jurors' lives and whatnot is dirty, very Orwellian.
Yeah, it just feels dirty. Feels like after I read some of those, I was just like getting physically ill reading that stuff. I was like, this is what they were doing.
Don't present as a DA's office. They present as a law firm of mob lawyers when they do stuff like that. I mean, it's strange.
And they've been dealing with this for decades. I mean, people in the chat are saying, yeah, and I know because I have ties to that exact county. And I've been hearing for decades how corrupt Norfolk County is. And it's not new for the people that live there. They've been dealing with this for decades. And so took the Karen Reed case to finally expose it. And hopefully we'll see some progress, or they will. We don't live there. So
yeah, no, it's crazy. But it's good content for you though, right?
I guess so. Yeah, but it is exhausting. Isn't it exhausting? Oh, all right. Well, it's college football season, so we got that going for us. All right, you have a game this weekend?
Well, yeah, ASU is playing Mississippi State tomorrow. That's kind of a big one. And
all right,
of course,
Colorado, Delaware tomorrow. So let's go Buffs.
That's a win, but not a good start for last week. But we won't talk about that for you.
Yeah.
Patriots this weekend. So yeah, no, it's football season finally, so that's good.
I'm not ready for the summer to be over, but
I know.
Hope you had a nice vacation. Were you in Florida?
I was in Florida, yeah.
Florida?
Yeah.
A couple weeks though. I felt like you were away for a really long time.
Yeah, no, it's good. I mean, it's not what I would call it's Florida in August. Who the hell chooses to go to Florida in August? It's a
You do.
strange, well, the timing works out for us, but
I know.
it's a strange time of year to choose to go there. But yeah, no, it was fun. It was a good trip.
It's hard with the kids because, they're off in the summer, so that's the time to go. But, you try to go down there between Christmas and New Year's and forget it. You're paying an arm and a leg for the plane tickets.
You go see family. We went and stayed out at Disney for a while. I don't that my daughter pulled out the sword in Disney, which was
Oh,
like lifetime achievement award for all of us. The sword and the stone.
yeah.
So like in Disney World, they have the sword and the stone.
Mhm.
Everybody, kids line up to pull it out, and it never gets pulled out until I guess the guy watching in the sky once every whatever decides, and he saw her, or well, I'm ruining she did it. Who am I kidding?
Oh,
And
that's amazing.
so she pulled out the sword, and it was like it's amazing the little things that actually become highlights of these kind of trips, because the look in her face was like, holy shit, that never happens. And
Oh, wow.
I
Do
have
they
like,
get anything if that happens? If they get to pull it out, do they get a special award or anything?
no, they get a lot of cheers though, because everyone is shocked because no one ever sees it except on the internet. So yeah,
Wow. It's like winning the big, casino prize at the slot machine, right?
for a
For
9-year-old
a
girl,
kid. Yeah.
it's a big deal. Yeah,
That's
I
a
mean,
big deal.
not quite, meeting Taylor Swift, but it's up there.
Yeah, you did that too, though, didn't you? I would like
Kind
to meet Taylor Swift.
I mean, not directly, but yeah, at her premiere, like yeah, that was kind
That's
of
awesome. That is awesome.
Yeah.
What else? I just see today that Alan Jackson appeared on the Fraser Bohm case in California for the Pepperdine, or for the kid that ran over the 4 Pepperdine students on the PCH, and apparently, there's a nice picture of him in the New York Post in court. And Fraser Bohm must be like 6'5" because he's towering over Alan Jackson. And Alan wanted to reduce his bail from $4 million to $2 million, and the judge was like, "Yeah, no,
Is he incarcerated? He's not incarcerated.
no, he's been out." Originally, the bail was $8 million, $2 million for each murder charge.
Well, it's
A very
It's-
sad case all around.
it is, but most judges, if someone's out and made bail, don't symbolically reduce bail if you're already out. I mean, if you're incarcerated on 4 and say I can afford 2, there are judges who might say, well, that works for me. But I mean, I wouldn't read into that.
No, it just popped up on my New York Post feed. That's why I thought I'd mention it, because we're on the phone. We're on the phone together. We're on the air together.
We're on the air.
We're
I didn't know that was in the New York Post, but they're starting a LA New York Post or a California Post. Have you seen this?
No.
Yeah, the New York Post is going Hollywood with a full California. I think it's called the California Post or the LA Post now, and they're going to have a full staff, and it's going to be completely Southern California.
Page 6 all the time. It's just all page 6.
But so I think like a lot of their like true crime wackiness, like we get in New York all the time, maybe will become, a thing out there too. So that's interesting.
Wow. What else you got? Closing thoughts? I'm exhausted. I was on for hours before doing the Cardi B thing, and now I'm ready for bed.
Yeah, no, nothing. I'm tired. Gonna get back to it tomorrow morning. It's kind of wash, rinse, repeat. At least for the next several days. I'm going to Massachusetts next weekend for some things.
Oh, are you going to be at the Wilbur? Everyone should go buy tickets, by the way, to Turtleboy's live show at the Wilbur next Friday night. It's a week from today. There's only like 100 and something tickets left, and it's going to sell out. I'm convinced, because a lot of people go last minute. So I think it'll be a sellout.
But so 2 trips like in the span of 2 weeks. So a lot of travel this month because we have court at the end of the month. So, gonna budget my time and hopefully finish up all kinds of projects before then. Hopefully.
Sounds good. The whole Ghislaine Maxwell, I think it was Ghislaine Maxwell, all those survivors came out. And I know that you've been working on something such as like that you haven't really disclosed publicly, but you have said to Nurse Kim and others that I've seen you on their shows that people are going to be shocked when they find out who may or may not be involved in some of these things, right? Involving Ghislaine Maxwell.
Yeah, although I mean, what I had said was, I mean, Epstein is kind of like a secondary thing.
Right.
I mean, he's just a dead pedophile,
Right.
and he's involved in all these kinds of things. But you know, at least the stuff that I'm dealing with really has nothing to do with his island, with his jet, that sort of thing. So whatever the victims are who are going to speak out, and I hope they do, and I hope they name them all. I know I saw the article.
Yeah, they did some sort of a closed door meeting with some
I mean, I would be fascinated to know if there was any overlap. I don't know, but I mean, Epstein and Maxwell are just a small part of a larger problem involving names that, quite frankly, are, you know, 50 times more noteworthy than they. I mean, Epstein and Maxwell are known because they're pedophiles. I mean, that's literally why they're famous. I mean, Maxwell has an interesting family situation, I guess,
Mhm.
with her lineage, but you know, they're a part and parcel of all this. And you know, what I had said to Kim and Mike, and with what's going on with Maxwell, she's not going to get part. There's no way.
Yeah, I don't think so either.
All
One
political stuff. It's not going to happen.
one of the Nancy Mace, I think that's her name, was so shooketh coming out of that meeting where the survivor spoke to her that she said she was like, she wants to see Prince Andrew in handcuffs, like today, tomorrow. Like that's how shook she was. And she had originally not been in favor of this whole thing. And she was spun, and there's video of her coming out of that meeting, and scary stuff. Did you just freeze on me? Or did I freeze? What? I think you froze, Mark. You there?
Andrew has been named by many people, right? So I don't need to say anything other than you know, he's embarrassed the royal family. He's kind of pariah. You know, he paid a civil settlement to you know, Joffrey before she passed away. I think, you know, he claimed he regretted that, whatever. But you know, again, there's so many names internationally in all walks of life, entertainment, politics, business. Yeah, I think it'll just shock the hell out of everyone, but not really, if you know what I mean.
Exactly. I mean, we'll be like shocked but not surprised.
Right.
I mean, a lot of this stuff has been whispered about for decades, and these people, and
Yeah.
it's
But
horrifying for the victims.
I mean, I'm really curious to see what comes out of the victims who had assembled and got together and said they're going to name names. And again, I hope to God they do. There's, you know, no quarter. Do it all.
I agree. I don't think Virginia Giuffre took her own life either. They were saying that it was a suicide. I don't believe it.
I'm not going to speak on that, but what a horrible thing.
Horrible. Horrible. All right, I'm going to say goodnight to you so that I can send thanks some people.
Okay.
Thank you so much for jumping on with me.
Great. No, it's
Can't wait to see you soon.
Yeah, see you soon, and you know, see where we go.
See you when I'm looking at you.
Okay.
Okay, good night.
Bye.
All right, you guys, I got a couple of people to thank here on the Such Super Chat. Wasn't that fun? Wasn't that so fun? Bederow Bucks. Thank you, No Love of the Traveling Trooper, for the Bederow Bucks. I appreciate you. Rob Berman says, it's like Kate Peter used the MSP to get back at Turtleboy, all because she had a beef with him. MSP has treated her like private police force. Disgusting. Yeah. She is fueled by her hatred for him, in my opinion, and really not even in my opinion, because she has publicly said that many, 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 many times. They used to work together. She was I don't know if she was ever pro Karen Reed, because I think they ended their relationship, their working relationship, Aidan and Kate, before the Karen Reed case happened. But she makes it her life's work to try and destroy him. She has not succeeded, and I don't think that she will. But she's also gone dark. People have said that she's sort of missing right now. She's usually very active on social, and she hasn't been. So they used her as a not so confidential informant because she was telling anyone who would listen that what she knew and how she didn't say how she knew it, but she knew a lot of things that were not publicly available to most people. Thank you, Kel, for thanking me for a fabulous Friday. It was Fun Day Friday, wasn't it? We're going to do this every Friday. Hey, it's May says, what I've learned is the courts at all levels waste tax dollars. It makes me sick. I was physically ill going through those invoices, 500 pages of them. I'm an empath, so those things affect me deeply. Thank you, Paul Youngs, for gifting a membership. And Bruce West says, look at the bright side. They got the OUI. You know, they did. It only cost them a couple $1 million. Dawn says, I'm getting butterflies thinking about next Friday night at the Wilbur. I've never been a celebrity fangirl, but I love everyone in the free Karen rating free Turtleboy try. And you know, that's so cool that you're going. And it's so cool if you're going alone, because I think a lot of people are like, I don't want to go alone. You know, I wouldn't want to go alone. But think about it. You're going to be surrounded by people that you have so much in common with, who are all there for a common purpose, and you're just going to meet people. So anybody who's like, I don't want to go because I don't want to go alone, you should go. There's single seats available, and there's also still like at least 100 tickets available. So I would just do it. Just buy the tickets. Just live your life. Buy the tickets. Go if you can. It's going to be fun. Go last minute if you want. Thank you for your super chat. Crazy Cat Lady says, we love you, Mr. Bederow. And Lily the Good Dog says, if Turtleboy's case did not go to trial, will the public not see any of the impounded discovery? Likely not, unless that protective order is ever released. Likely not. However, those of you who want to make public record requests might be able to get it that way. So say no more. Say no more. Winky wink. Lana Del Turtle says, I don't want to go alone. You're going to go, aren't you? Are you local, Lana? Everyone should just go. But a lot of people listen. Younger people don't like to do things alone. It took me a long time in my life to want to go places alone. But I don't mind eating alone because I know what I bring to the table. You can use that if you want. And also, you're going to be around people. Okay? I'm exhausted. It's been a long day, and this girl needs to sleep. Back to school time. So that means I got to get up wicked early to drive. And I don't like that, because this girl likes her full on 8 hours. Full on 8 hours. All right. Thank you so much. If you didn't watch that Cardi B show that I did earlier, you might like it. It's really funny. Even if you don't know who Cardi B was, I really didn't. And I'm not a fan of her music, but it was funny. Her testimony was good, and we needed a nice palate cleanser and Adelson detox, if you will. Lana, wait a second, Lana, hold on. You're in Worcester? Do you know about this case? This case that they just started picking a jury on? Hold on, stop, because you may need to go to court and sit in on this trial. Hold the phone. The name of the defendant is Joshua Hubert, I think. Wait, hold on 1 second. I don't want to give you the wrong name. This is a 2017 case. Joshua Hubert, Hubert. Do you know about this, Lana? In 2017, he kidnapped a 7-year-old girl who was a friend of the family. He had been at the house for a barbecue at like 2:15 in the morning, threw her in the back of his car, bound her, gagged her, raped her, and then threw her off a bridge in Worcester. She lived. She swam 100 yards to shore. She went and knocked on a door. The woman answered the door and took her in. And this guy has been out on bail since 2017. They picked a jury, I believe, yesterday. The trial's supposed to start, I think, on Monday. I don't think they're going to televise it. I think Court TV or somebody did make a motion to try and get cameras in there. But Lana, if you're there, yeah, he's been out since 2017. Attempted murder and rape of a 7-year-old. And now she's 15. And I think the excuse was we should keep the cameras out because she's a teenager. But we know what they can do. They can turn off the cameras when she's testifying and not photograph her. And it's possible. And I think they need to televise it. And maybe, Lana, you need to go check it out and see what's going on at the courthouse. And Jenna says, yes, I remember it well. 4 miles from my house. It's crazy. Nobody's reporting on it. There was an article in Mass Live that is behind a paywall for me, so I couldn't even get to it. There's like very scant articles on it, and it's a case that needs coverage. And thanks, Ilana, and email me if you find out anything. Aaron Spencer's attorney filed a motion. Yes, I did see that. It is a very interesting motion. Lana, maybe you could take a look at that motion. They want to dismiss the case on Fifth Amendment grounds. It's a great idea for a motion, but they're saying that because they did not indict Aaron Spencer through a grand jury, I think I read it briefly, so don't quote me on this, that because Arkansas does not have a required grand jury system, it should be thrown out on those grounds. It is a very complex constitutional argument. I had a chance to read it. I think it's 5 or 6. I don't remember how long it was, but I didn't have enough time to do enough research on it to be able to opine on it in an insightful way or an intelligent way for you, because quite frankly, when I start reading constitutional arguments like that, my eyes glaze over and I really need to be awake and be able to do the research. It's a stretch. And but it's a novel argument. Look, they argued in front of the Arkansas Supreme Court about the unconstitutionality of the gag order in that case in Aaron Spencer, and they won. And the Arkansas Supreme Court seems to like these attorneys, and it may be time for change in Arkansas. So yes, I did see it. To answer your question, haven't had time to look at it intelligently yet because I was putting together furniture for both of my college-age daughters. And somebody wrote in my comments earlier, teach them how to put the furniture together. And I'm like, okay, well, they were doing it with me. I'm their mother. Should I just abandon my children and send them furniture from IKEA and let them put it together? It was such a weird comment, but that's what I deal with on the daily. So there's that. And Julie says, hey, it's almost 24 hours later. Just wondering, did they catch Wendy at the airport trying to escape? Oh, here's something that I wanted to bring up about the Adelson thing. Because I didn't really watch the trial, honestly. And I haven't followed that case. I'm not one of these Adelson stands that's been following all the trials for the past 11 years and whatever. To me, I know a lot of women like Donna Adelson, very, very, very in your face mothers who are overbearing, overly involved in their children's business and make it their business to make their children's business their business and do everything that they can to, Budinskis. So I don't know if there was a lot of evidence connecting Donna Adelson to the planning of the murder for hire or whether she found out after the fact. Because here's something very interesting. And I did the research on this when we were looking at the Gabby Petito and Brian Laundrie case. And a lot of people were asking, why aren't they not charging Roberta Laundrie, and I forget the husband's name, with accessory after the fact? And the reason is that in Florida, a parent cannot be charged as being an accessory after the fact. It is a weird law. It's a Florida law. And so I'm thinking to myself, if Donna Adelson had just tried to use the defense that I didn't have anything to do with the planning of it and I didn't know anything about it until after it happened, and then I found out that Charlie did it and I was so mad, I was just trying to help him. Maybe she would not have been able to have been charged with anything. Look it up. That's the statute in Florida. Parents, siblings, and I think children cannot be charged as accessories after the fact in Florida. That's the law. And so I was just thinking, why didn't she just argue that? And then people say there's a lot of evidence that she was involved before it happened. So there's that. But maybe she didn't want to roll over on her son either. I don't know. But it was just an interesting thing that I thought of because it reminded me of why the Laundrie parents were never charged, right? Because they may have helped Brian Laundrie after the fact when he came back with the van. Where's Gabby? And maybe he told them, and then they were like trying to cover for him and, cover up what he did. They can't be charged in Florida. Weird, right? Weird. Just a thought. Anyway, all right. Thank you, my friends. Thanks for being here with me tonight. Please hit the like button, share the stream out, do all the things that YouTube likes because, algorithms and all that stuff. And thank you to the moderators and thank you to Mark Bederow for joining me tonight. He's like, she texted me and said, I see people in the chat wanting to know if I'm coming on with you. And I'm like, do you want to? Because I know he's not allowed to say a lot about this case because, there's rules. But then we got to talk about some other things too, right? So that was interesting. Thank you all. Stay cool, stay kind, stay classy. I know you can do it. I know you can. I'm going to see you real soon. Probably not tomorrow, but absolutely Sunday. I think it's time for like another Nurse Kim and Melanie girls' night. Maybe we'll do a slumber party. Maybe Sunday night. Would that be fun? I'll see what Kim's doing if she wants to come over to my house and we can have a little slumber party. Wouldn't that be fun? All right, you guys. Peace out. I love you with all of my heart. And I'll see you soon. I'm going to